Hello everybody, this is attorney Jesus Martinez, and I just wanted to make a video about the recent news on the public charge rule. As many of you know, public charge has been in place for several years, but the biggest change was under the Trump administration, where they tried to augment and create new characteristics, new requirements, new things that could make you be deemed a public charge. And in this video, we're going to discuss that new change as of today, the 9th of March. So stay tuned. So there's several different articles discussing this, and pretty much the news recently came out as of today. The Supreme Court agrees to dismiss challenge to Trump public charge rule. And let's see, let me pull up the actual document. So this is the proof of service. This is the document. And as you can read right here, it's a joint stipulation to dismiss. Pursuant to Rule 46.1 of the rules of this court, all parties respectfully request that this case be dismissed. No fees are due to the clerk, and each party will bear its own costs. And that's, so pretty much both sides are agreeing to dismiss the court. So before, when Trump was in office, I believe the state of New York and a few other states were challenging the public charge rule. And once Biden came into office, this case was still ongoing. And pretty much right here, what it's saying is that the Department of Justice, under Biden's authority, and the Solicitor General, the Attorney General of New York, they're both agreeing jointly to not proceed forward with this case. And for the Rule 46.1 of this court, so here are the rule that it's referring to. And Rule 46.1, at any stage of the proceedings, whenever all parties, both sides, so the person bringing forth the action, bringing the lawsuit, and then the person defending it, file with the clerk an agreement in writing that a case be dismissed, specifying the terms for payment of costs, and pay the clerk any fees then due. The clerk, without further reference to the court, will enter an order of dismissal. So pretty much, you know, the lawsuit that New York was bringing, it's dismissed. The Biden officials in the Department of Justice are deciding to not proceed forward with this. So pretty much the public charge rule will, you know, depending upon what proceeds forward, but up until this point, it should no longer be in effect. What I would say to that, the caveat I would say is, you know, let's wait for USCIS to, you know, make their notification to state what they're going to state on this. And by that I mean, you know, once they update their website, once they you know, mention that they're not proceeding forward with this, that it's no longer in effect, then, you know, that's when I would be a lot sure, and I would rest easier for individuals that are going to apply, wondering about whether they should include that form or not. You know, once we have that on the USCIS website, then that's going to be a more sure thing. And what I would mention with that too is, you know, two things. You know, the first thing is that with deferred action, you know, even though the Supreme Court made their decision, you know, it was about a month and a half roughly before USCIS stated their decision, you know, saying that they were not going to accept first-time DACAs because they, for whatever reason, they just weren't going to do it. So I don't think that's going to happen here because of the president. But I would say, you know, similar to that, how it took USCIS a while to update their website, I don't think it's going to take them that long here, but just be mindful that, you know, once it's on the USCIS website, you know, that's when we're in the green, so to say. So I would just keep that in mind. We posted a link to these websites, so if you want to read it in full, you can. If you learned something, please let me know by hitting that like button. Don't forget to subscribe. If you want to see videos on different topics, please let me know. Thank you. God bless, and hope everything goes well.